Hello everyone, I'm Nazarat Fatima. Welcome to Live Law. In this video, we'll talk about the reliability of a sample which is not collected in the presence or under the supervision of the magistrate. A person was convicted by the special judge under Section 15 of the NDPS Act for possession of poppy husk. The High Court had dismissed his appeal and finally he filed an appeal in the Supreme Court. A division bench of Justice Abhay and Justice Rajesh Bindal were hearing the appeal. The appellant argued that the case of prosecution is vitiated as the sample drawing was not done in accordance with the provisions of the NDPS Act. It was argued that the sample was drawn by prosecution witness 7 and his examination in chief would show that the samples were drawn immediately after seizure of the contraband. The Supreme Court in this case reiterated that the process of drawing of samples under Section 52A of the Narcotics, Drugs and Psychotropic Substances Act 1985 has to be in the presence and under the supervision of the magistrate. The entire exercise of collecting the sample must be certified by the magistrate to be correct. The Apex Court, while observing so, relied on the decision in Union of India versus Mohanlal and another to reiterate that there is no provision under the NDPS Act that mandates taking of samples at the time of seizure. The drawing of samples must take place before a magistrate, and since most often seizure occurs in the absence of the magistrate, the question of drawing of samples at the time of seizure does not arise. According to the said decision, this is especially important as the samples drawn and certified by the magistrate constitute primary evidence for the trial. The Supreme Court found the procedure followed by the prosecution to be contrary to the law laid down in the case mentioned before. As such, the court allowed the appeal and set aside the conviction and sentence of the appellant. It said, and I quote, "Hence, the case of the prosecution is not free from suspicion, and the same has not been established beyond a reasonable doubt. Accordingly, we set aside the impugned judgments insofar as the present appellant is concerned and quash his conviction and sentence." That's all about it for now. We hope you like our content. If you do, please like and share our videos. Also subscribe to our channel on YouTube and don't forget to press the bell icon for notifications. Thank you for watching.